This is your panel on Is Originalism Possible? Historical Indeterminacy. And I'm starting to speak in the hope that we can get people seated and begin rolling. But you needn't pay terribly much attention to what I'm going to say. The panelists are the real treat. This is, however, a special delight for me to moderate this panel this morning, although I have to admit that everyone whom I've told I'm a moderator has expressed shock and incredulity. I am usually cast in the role of immoderator, intemperator, or provocateur. But I'm going to try to be relatively even-handed today. Still, one might say, in opening in an attempt to stir up the troops, that I would not be surprised if a good many of us here would, at this date, paraphrase our sometime hero and say that moderation in defense of originalism is no virtue, and extremism in its advocacy is no vice. But be that as it may. Everybody, it seems, has deferred things to our panel. What then are we to do? Our concerns are those raised by Paul Brest in his famous 1980 article, and elaborated since by, among many others, our own Bob Barnett and our own Michael Perry. Just to lay some of the framework by mentioning, or lay out some of the framework by mentioning some of the key issues that I think our panelists will touch on. First, can you really capture the original intention or even the original understanding of the terms of the Constitution or the Bill of Rights? Is the task of objective constitutional history here simply insurmountable? Are the problems of historical indeterminacy just too great? Is originalism possible? Now, one answer to this question consists of just 10 words. Is originalism possible? Of course it is. See Raoul Berger or Lino Graglia. But let's assume that you're not satisfied with that answer. Let's assume that you're Paul Brest or Bob Barnett or Michael Perry. You might well ask, isn't it true that the Constitution was a difficult political compromise between at least two groups that put categorically different interpretations upon the clauses on which they agreed? And if it wasn't understood clearly then, how could it be now? Second, hasn't the passage of 200 and some years even further clouded the historical record? Wouldn't we need to live in the world of the framers actually itself in order really to understand their words as they used them? And given that the values and the conditions of our world have changed so radically, as modern analytical philosophy, as literary criticism, or as linguistic theory teaches, our reading of the text will inevitably be ours and not theirs. Isn't this true? And finally, if we can determine anything about the framers' historical understanding, isn't it that they couldn't have anticipated everything that would happen 200 years down the road and wouldn't have wanted us to act as if they could have? They were not believers in a dead hand, as we were reminded yesterday. Now, these and other questions should soon be decisively and finally answered for you. Our four distinguished panelists will each speak for probably a little bit less than 15 or so minutes apiece, and then we'll throw the floor immediately open for questions, clarifications, elaborations, and denials. We are a daring panel, and we're going to engage in a bit of interpretivism just to begin. We're going to depart somewhat from alphabetical order for architectonic purposes. Suzanna Sherry of the University of Minnesota Law School will be our first speaker, followed by Randy Barnett of the Boston University School of Law, then my colleague Gary Lawson, and finally Thomas McAffee from the Southern Illinois University School of Law. Now, if I've got this right, and you may want to keep score, our four speakers will answer the question, is originalism possible? No, maybe, and yes. Our speakers will follow each other's seriatim without further introduction from me, and we'll go directly from their remarks to the audience in order to let them disagree with each other indirectly as a result of your questions. Without further ado then, Suzanna Sherry.
My understanding of Steve Presser's intent is that we are departing from alphabetical order to give me the job of proving that history is indeterminate, so the rest of the panel can talk about what to do about that fact. Of course, if I'm successful in proving that history is indeterminate, it's not going to help the rest of the panel, since by the time they talk, my remarks will be history. I want to leave aside the normative questions, and I also want to leave aside a number of empirical questions, such as the one that Larry Alexander raised last night: who is Fred? Whose intent are we looking at? What I want to do is just see what happens if we try to do some historical analysis, try to do some originalist analysis on some interesting, controversial, and contemporary constitutional questions. And in fact, there is a current case before the Supreme Court, which should be decided in the next few months, that raises quite a few of these controversial questions, or could be interpreted to raise them. And that's the Rosenberger versus University of Virginia case, in which a religious student organization is suing the University of Virginia for its failure to fund this particular student organization's newspaper when it funds other newspapers. And the University of Virginia's original defense, although they have since abandoned it, is that it would be an Establishment Clause violation for a state university to fund a religious newspaper. So it's a very interesting free speech, Establishment Clause, and so on case. And imagine that you were, as I assume many of you either will be or want to be, clerking for a Supreme Court justice this term, and the justice happens to be a very strict originalist and says, in order to figure out what happens in this case, I need you to go out and do some research and find out how the framers would, however we define the framers, would have answered the various questions that are or might be raised by this case. Now, since you are neither professional historians nor have unlimited time, you decide that the best thing to do, or the best way to start at least, is to go and see what other people, what scholars who have carefully studied the history have said about the various questions. All right, well, when I'm wearing one of my other hats, I'm a federal jurisdiction teacher, and the first thing I always tell my students, the first thing you do is make sure that you have a ticket to ride on this particular train. In other words, is there jurisdiction? Well, the students are suing the University of Virginia, which is a state entity, and so there is at least a question of whether the 11th Amendment, which sovereign immunity, prohibits this suit. Now, the 11th Amendment, for those of you who haven't had federal jurisdiction, says, and here I'm reconstructing from memory because unfortunately, unlike Michael Dorff, I don't carry a constitution in my pocket. The 11th Amendment, you can check how accurate I am. The 11th Amendment says that the judicial power of the United States shall not be construed to extend to suits in law or equity commenced against one of the United States by citizens of another state or of a foreign state. And it doesn't say anything about suits commenced by citizens of the same state. So then the question is, well, the University of Virginia students are citizens of the state of Virginia. Is their suit barred by the 11th Amendment? Let's go see what the history says. Well, a few hours in the library will yield you a very clear result of maybe, maybe not. On the basis of very careful historical analysis, Calvin Massey says that the state would be immune, and William Fletcher says that the state would not be immune. These are only two of the most prominent scholars who have studied the 11th Amendment question, and their disputes are mirrored in the disputes of all the other scholars. All right, well, let's follow the modern law on that, and we'll decide the question, and we'll assume that the 11th Amendment doesn't bar the suit. Let's move on to a different question. Maybe we can go back to what was a previously settled question, but could still be reopened. Does the First Amendment prohibition do the First Amendment provisions on freedom of speech and religion even apply to the states? That is, as a matter of 14th Amendment original intent, does the 14th Amendment incorporate the first 10 amendments to go against the states? Again, you go back to the library, you spend the same few hours, and you get exactly the same answer. Michael Kent Curtis says, after a careful historical analysis, yes, the 14th Amendment was intended to incorporate at least many of the first 10 amendments, and Charles Fairman says, no, it was not intended to incorporate. Again, both of them are careful scholars. They look very carefully at the historical evidence. In fact, they look at some of the same evidence, and they reach completely opposite conclusions. All right, well, I guess that's not going to help us. Maybe we can look at some of the substantive issues. One of the substantive issues that, as I said, the University of Virginia has since dropped is the Establishment Clause question. Would the Establishment Clause, in fact, prohibit the University of Virginia from funding this particular student organization? Because if it does, then you've got a somewhat different speech question. Well, for that you have to figure out what the substantive elements are of an Establishment Clause violation, and two separate questions have been raised in the literature. First, can you aid religion in general as long as you don't discriminate among religions? This is known as non-preferentialism, and it has a number of supporters. Obviously, at this point, the University of Virginia would have different responses. So go back to the library, try and figure out whether the framers intended to prohibit aid to religion generally, or whether they only intended to prohibit aid to particular religions as opposed to other particular religions. Did they only intend to prohibit discrimination? And again, you're going to spend the same few hours and you're going to get the same answer. Robert Cord says yes to non-preferentialism. That is, Robert Cord says that the framers intended only to prohibit discrimination among religions. Douglas Laycock says no, the framers intended to prohibit discrimination, to prohibit aid to religion generally. And we haven't even begun to look at what aid to religion means. It just gets harder. Well, there's a different question about the Establishment Clause, and that's the question of coercion. That is it all right for the government to aid religion as long as they don't coerce anybody into believing or particular religions or attending particular religious services or aiding religion in any way? Is coercion a necessary element of an Establishment Clause violation? Michael McConnell says coercion is a necessary element, that is, that there is no violation unless somebody is coerced. Douglas Laycock says that there isn't, that coercion is not a necessary element. In other words, that there can be an Establishment Clause violation even if there's no coercion. Again, as I should have said, careful historical analysis, often the same historical evidence, two opposite conclusions. Well, if everything else fails, you can pick my favorite provision, which is the Ninth Amendment, which, again, quoting from memory, is that the enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, this has been mentioned several times in preceding panels, but nobody's really talked about so much of the historical intent, but there are a number of articles out there, and in fact, Tom McAfee and I disagree completely. Tom McAfee says that the Ninth Amendment does not create any judicially enforceable unenumerated rights, and I suggest using much of the same historical evidence that Tom relies on, that the framers did intend to create and judicially enforceable unenumerated rights. So on one case, one relatively difficult case, we are now 0 for 4 in terms of whether historical analysis gets us anywhere, since on the basis of the same evidence and the same careful historical analysis, we have reached opposite conclusions on every single issue. There are similar disputes about anything basically worth taking to the Supreme Court. There are similar disputes about affirmative action. There are similar disputes about almost anything. Raoul Berger yesterday mentioned one thing about which there seems to be very little dispute, although now perhaps there is more dispute. He suggested that the 14th Amendment quite clearly did not talk about voting, was not addressed to voting. Well, there may well be agreement on that, although from what I've heard earlier today, there might not be. But part of the reason that there is agreement on that is that the historical evidence includes the 15th Amendment, which is quite clearly about voting, and which remedies the failure of the 14th Amendment to talk about voting, and which also essentially makes the question whether the 14th Amendment talks about voting to be something of a moot point. So if there is still a live controversy, that is, if we don't have the type of evidence that the 15th Amendment provides, then we can't reach an answer. Do I have a few more minutes?
About
30 seconds. Everybody I've talked about is either a law professor or a political scientist. Why haven't I talked about any professional historians who do not teach in law schools? And the answer is they know that history is indeterminate, and they don't even bother trying to answer these sorts of questions.
Ever since the revival of interest in originalism that occurred in the 1980s, largely at the instigation of the Federalist Society and its members, critics have charged that for a variety of reasons, it is impractical, if not impossible, to determine the intentions of the framers. Moreover, they argue that we today should not be bound by the intentions of a few men who lived and died over 200 years ago. In my remarks this morning, I will argue that we cannot assess either the practicality or the justice of discerning original intent without first asking why it is we are consulting the intentions of the framers. And I'll discuss two reasons to consult the framers. The first views the framers as wardens. The second views the framers as designers or architects. First, the framers as wardens. Let me begin by posing the following question. Does a law enacted by Congress and signed by the President create a duty of obedience in the people? Would it be appropriate not merely to punish, but also to condemn a person who disobeys, for disobeying a law, for having done something that's morally wrong? To put the matter starkly, did the Branch Davidians in Waco have a duty in conscience to submit to the commands of the alcohol, tobacco, and firearms agents who came calling one morning, carrying genuine assault weapons? Did Randy Weaver do something wrong, not merely illegal, when he refused the order that he surrender to the FBI? Although most constitutional scholars do not consider these sorts of questions explicitly, those attracted to originalism imply that a law creates a duty of obedience if it reflects the will of the people, and in practice, this means the will of the majority of the people. What then is the role of the Constitution? According to this view, the Constitution places limits on what laws a majority may impose on the people, but these limits are themselves a reflection of majority will. The Constitution reflects the will of the majority who elected representatives to state constitutional conventions, a majority of whom, in turn, voted to ratify the Constitution. Because the Constitution, like a statute, is viewed as a command from the majority, we need to determine the intentions of those who issued the commands to determine their meaning. Of course, as many have already noted, and Suzanna just noted once more, this is exceedingly difficult to do. How exactly does one determine the collective intentions of thousands of persons who elected hundreds of representatives who then voted to ratify the Constitution in 13 different assemblies, not to mention the intentions of those who voted for thousands of state legislators who in turn voted to ratify the various constitutional amendments at different points in our history? So, as a surrogate, we consult the statements made by various members of the Constitutional Convention, supplemented perhaps by statements made by members of ratification conventions, with the assumption that others shared these stated views. But these arguments can get extremely complicated, as witnessed the debate between Professor McAfee, Professor Sherry, and myself concerning the original meaning of the Ninth Amendment's protection of the rights retained by the people. Moreover, the difficulties of discerning framers' intent increase as we get increasingly specific. Would the framers have considered a wiretap to be a search? Would they have considered flag burning to be a form of speech? Would they have considered cable TV to be a form of the press? These specific inquiries are necessary when we view the framers as wardens, having issued commands, the meaning of which depends on their intentions. In response to these difficulties of answering very specific questions concerning framers' intent, proponents of originalism employ a number of techniques. First, and often, in the absence of evidence, a hypothetical group of framers are consulted, as in, the framers would have been shocked to learn that the First Amendment protected fill in the blank. One may think of this as a form of constitutional channeling, in which originalist clairvoyants ask, "Oh, framers, tell us, what would you think about the following law?" Now, other originalists, such as Lino Graglia and many, many others, adopt the following technique. They effectively adopt the following presumption. If a subject is not specifically mentioned in the text of the Constitution, it is said to be silent, in quotes, on the issue, and the government therefore has plenary power to do what it wishes. So because the Constitution does not mention flag burning, or cable TV, or marijuana, or contraception, or alcohol, for example, it is presumed that the majority, acting through its representatives in government, may regulate or prohibit these activities as it pleases. Since the Constitution does not mention wiretaps or electronic surveillance, the government is not restricted in using these techniques by the Fourth Amendment. Thus, the difficulties surrounding determining original intent are resolved by a simple default rule favoring enhanced government power whenever the framers' opposition to such activity by government cannot be divined. Notice how this originalist method leads to what can only be described as, well, the Leviathan, a Hobbesian result which would have shocked the conscience of all the hypothetical framers that I have consulted on the subject. Yet many originalists seem unembarrassed by this disconnect between the results of their originalist interpretive methodology and the views of limited government that were universally accepted by the founding generation. And this may be because they are really at heart majoritarians first and originalists only second, if they are originalists at all. And, in addition, there is something curious about the appeal of the framers' intentions that is worth stopping for a moment to consider. In my experience, persons from every political group and every interpretive school are fascinated by the intentions of the framers. They are not, however, nearly so interested in the intentions of delegates to state ratification conventions or to the attitudes of the general population at the time of the framing. Now, this suggests to me that we are interested in the framers' intentions not because they are a surrogate for the will of the majority of 1787, 1789, or 1868, but because we respect their opinions. Perhaps they are authorities, not in the sense that a statute is an authority, but in the sense that Story, Kent, Williston, Corbin, and in this hallowed halls, Wigmore are authorities. We respect their opinion because we think they knew what they were talking about. The weight of their experience, knowledge, and reflection influences us in a way that sheer majority will cannot. That the framers advocated a particular idea suggests to us that it is a good idea, not merely that it reflected the preferences of the biggest or strongest group. Now, with this in mind, let me sketch the view I'm going to call the framers as designers. Suppose that instead of viewing the Constitution as representing a command of a long-ago majority, whose intentions we need somehow to discern, we view it as the blueprint for a machine that was designed to perform certain functions. In this case, the machine is designed to make laws to accomplish certain ends, which laws are supposed to be binding in conscience on the citizenry. Think of the Constitution the way you might think of a machine designed to make sausages. We want a sausage-making machine to provide us with food, but we also want to ensure that the sausages produced by the machine are wholesome and untainted by disease. Because we do not want to have to inspect each and every sausage to see if it's wholesome, we want a machine whose design gives us confidence that it produces wholesome sausages. Similarly, a constitution specifies the design of a machine of sorts to produce laws that are beneficial and also laws that are not unjust. Laws which, because they are both necessary and proper, bind us in conscience. Yet because we cannot inspect every law individually, we need some confidence that the internal operation of the lawmaking process is designed to produce beneficial laws and to weed out those laws that violate the rights retained by the people. A constitution that establishes a lawmaking process with the requisite built-in quality controls can impart legitimacy on the laws enacted in its name. A constitution that fails to contain such internal quality control procedures tells us nothing about the justice of the laws it produces. We may obey like the Holmesian bad man to avoid punishment, but not because we are bound in conscience to do so. According to this approach, the framers are viewed as designers or architects of the lawmaking machine. We consult them when we want to know how the machine is supposed to work, not because they are a surrogate for the intentions of the people who lived 200 years ago, but because they might have special insight into the machine they designed, especially its internal quality control procedures. They gave its purpose and design much thought, perhaps more thought than we have, and we benefit from their learning, and I endorse Akhil Amar's suggestion that we benefit from their learning. More importantly, however, in designing this machine, they adhered to certain basic principles, analogous to the principles of engineering, and they thought of them as analogous to the principles of engineering. These principles are either sound or they are unsound. Adhering to them either leads to laws which bind in conscience, or it does not. If they are sound, then we need to continue to operate the machine according to these principles, or we will pay a heavy price. We need to learn about and adhere to the principles of the framers then, not because they rule us from the grave, but because the principles they discovered and embodied in their machine are as valid and useful today as they were then. The laws produced by their machine bind us, if they do, because they were produced by a machine that still adheres to the sound principles of lawmaking that they innovated. Consider another analogy. By cutting the cables on a suspension bridge, we violate the principles of that the bridge designers engineered into the structure. Though the bridge designers' intentions do not bind us, their design does. Assuming we share the same objective, we cut these cables at our peril. Similarly, by eliminating the safeguards built into the constitutional structure by its framers, we risk the adverse consequences they consciously sought to avoid. Now, notice some of the advantages of the framers as designers' way of looking at framers' intent. First, it explains why we remain so fascinated and influenced by the views of the small group of persons who framed the Constitution and who framed the 14th Amendment, just to name two instances. Indeed, we generally confine our attention to just a handful of the framers, such as James Madison or James Wilson or George Mason, as opposed to the views of other members of the Constitutional Convention or of the reigning majority of the time. We listen to them more carefully because we respect their opinion, perhaps especially the opinion of the chief architect or designer, James Madison, whose silhouette graces the stage this morning. Second, the second advantage is that this framers as designers approach answers the question of why we are bound by the decisions of a few dead white males. The answer is, we are not bound by their decisions per se. Instead, if we seek what they sought, then we must adhere to the principles they discovered and embodied in the Constitution, assuming these principles are correct. In sum, we are bound by the correctness of their principles, not by their source, though we consult their source to discern exactly what these principles are. It should therefore come as no surprise that scholars and activists who reject the framers' view of limited government should seek to undermine the operation of the machine they designed to effectuate these views. By the same token, some who share the framers' views of liberty might think them to have been mistaken in certain of their design decisions, for example, in refusing to abolish slavery, by failing to provide congressional term limits, to take a modern example, or by failing to find some means of protecting citizens from abuse by their own state governments. That was a design defect that was remedied by the designers of the Privileges or Immunities Clause of the 14th Amendment. The third advantage, and most relevantly for this panel, it means that we interpret the text of the Constitution by consulting the writings of the framers, but we do so to discern not their specific hypothetical intentions towards particular legislation, but the principles that they designed into the constitutional structure we seek to interpret. Such principles as federalism, separation of powers, judicial review, and freedom of speech and religion. To this list, I would also emphasize the principle embodied in the 10th Amendment that the government of the United States is supposed to be limited to its delegated powers, thus undermining an interpretation of the Commerce Clause that gives plenary power to the Congress. And it should come as no surprise that I would also emphasize the principle embodied in the 9th Amendment that constitutional protections of liberty are not limited to the few liberties that were expressly mentioned in the constitutional text, but that this protection extends as well to all other rights retained by the people. The meaning as well as the merit of these general principles are quite capable of being discerned today, and perhaps even better appreciated in light of our 60-year-long experience of having seen them violated. If the proof of the pudding is in the eating, then the immiseration and injustice by the modern welfare state is testimony to the wisdom of the framers. Indeed, one evidence of the obviousness of the framers' principles is the convoluted theories that have been invented to supplant them, such as the theory that the Second Amendment's protection of the people's right to keep and bear arms was intended to protect the state's power to maintain a militia. In sum, and we're there, the last page. In sum, provided we are looking for the right intentions and for the right reasons, a commitment to original intent is not barred by the indeterminacy of historical materials. Indeed, we are not so much committed to the original intentions of the framers as it is that we today share their intentions to limit the power of government so as to enhance and protect the liberty of the people. We are bound to adhere to their principles because we today accept them to be as useful to protecting liberty as are the principles by which one designs a bridge. We ignore both types of principles at our peril. One last question. Is the view I have called framers as designers a form of originalism? Because I have always associated originalism with the framers as wardens approach, I have never considered myself to be an originalist. But if John Macy is right, that we are all originalists, even, apparently, Cass Sunstein, as we learned yesterday, then perhaps this is an originalist perspective after all. But whether or not it is an originalist perspective, I think it is a correct perspective, and if this be treason, make the most of it.
I think that wasn't maybe, that was yes. Gary?
When prospective speakers who've never attended a Federalist conference ask me about format, what the panel presentations they're preparing should be like, what I usually tell them is 2 points and shut up. And that's exactly what I'm going to do. I have 2 points closely related, one about the nature of indeterminacy and originalism, and one about its consequences. A lot of speakers at this conference have explored aspects of uncertainty in the historical enterprise of originalism, both on this panel and on other panels. We've seen that there is uncertainty about what materials count towards establishing original meaning, the who is Fred problem from last night. Those of you who don't understand the reference, well, that'll teach you to skip panels. There's also uncertainty in how much various materials count. Suppose, for example, that we know both what Fred said and what Larry said. We're interested in both. We might want to know whether we care more about what Fred says than what Larry says, and there might be uncertainty in that. Once we've gathered all the materials, there might be uncertainty in what they tell us. That's the point that Suzanna Sherry was making quite eloquently. And there are additional elements of uncertainty. There's even uncertainty about whether the historical materials actually reflect history. Somebody should ask me in questions about the annals of Congress. But uncertainty is not the same thing as indeterminacy. Once we've gathered up all of the uncertainties, we still have to ask the question, okay, do they make the questions indeterminate? Or put another way, how uncertain do we have to be about an answer before we're willing to throw up our hands and say, I give up? Let me illustrate this with an academic example. And what I mean by an academic example is a self-promoting example. Consider for a moment the so-called necessary and proper clause of the Constitution. And I say so-called because everybody, and I mean everybody in the founding generation, called it the sweeping clause. And it's one thing to say that we're not going to pay much attention to the meaning of what they wrote. It just seems to me a gratuitous insult not to pay any attention to what they called it. So I'm going to call it the sweeping clause. All right, consider that clause for a moment. In a law review article a few years ago, Patty Granger and I surveyed the available historical materials, and we concluded that far from being a blank check to Congress to do anything it jolly well pleased, the sweeping clause was in fact an integral part of the constitutional design of limited government, in particular the oft neglected word proper. Remember, it authorizes Congress to pass all laws that shall be necessary and proper for carrying into execution. That oft neglected word proper essentially confined the national government through the laws that Congress enacts to its enumerated jurisdiction. To make a long story short, laws pursuant to that clause, and that's 99% of every law passed by Congress, have to conform to background principles of individual rights, federalism, and separation of powers. Congress had to obey the Bill of Rights before there was a Bill of Rights. It had to obey the 10th Amendment before there was a 10th Amendment, and it has to obey separation of powers, even though we don't yet have a separation of powers amendment. Well, all in all, a very powerful and, I dare say, elegant theory of the sweeping clause. But is it right? And the answer to that question depends on the relationship between uncertainty and indeterminacy. For example, if all we mean by an answer being right is that it is better than any available alternative out there, I think we have a slam dunk. The theory of the sweeping clause that we put forward accounts for the available historical evidence better, and I would say substantially better, than any competing theory of the clause that's been put forward. If that's enough, then we have a determinate meaning for the clause. We have met the meaning, and it is ours. But suppose someone says, well, wait a minute, that's not much of a standard. After all, if there are, let's say, 20 possible interpretations of the sweeping clause, to say that yours is better than the other 19 just means that it's better. It might be lousy by any objective standard. It's just that all of the other 19 are worse. So before we're willing to say that, yes, we have a determinate, correct meaning for this clause, we're going to ratchet the standard up. We're at least going to demand 50% plus 1, that your interpretation meets a preponderance of the evidence standard. Well, I happen to think that Patty and I can meet that one too, but let's suppose that we can't because it's more interesting. Then, if we're the best thing going and we don't meet 50 plus 1, that means no interpretation of the sweeping clause is going to meet the 50 plus 1 standard. Then you would have a genuine, bona fide case of indeterminacy. But in order to get there, you had to say something very specific and very powerful about the standard of proof that you're going to hold claims to. Just how much evidence are you going to require before you allow a proposition to be viewed as correct? And of course, we can imagine ratcheting the standard up even another level. We're not going to say that we have a determinate meaning of a provision unless we can establish one beyond a reasonable doubt. Now, I think Patty and I can give that one a run for its money, but we may well fall short. And if that's really the standard, if that's what it takes to make a provision determinate, then I think we'd have to say that the sweeping clause is indeterminate, as would be, I think, every other interesting clause of the Constitution. Moral of the story: in order to understand the extent of the problem of indeterminacy, you have to understand what the standard of proof is. If you ratchet up the standard high enough, if you demand enough from a theory, everything is going to be indeterminate. If you ratchet the standard down low enough so that all that you're asking for is the best answer that you can possibly attain, the zone of indeterminacy goes essentially to zero. All right, that's my first point about the nature of indeterminacy. Now, my second point: once we have indeterminacy, we've specified the standard of proof, we've looked at all of the uncertainties, and nope, no proposition meets it. What does an originalist do? And this is a question that's been punted off to this panel. I'm going to fair catch it. I won't let it bounce, but I'm not going to return it. The answer about what you do depends on who you are and what you're doing. If you're an originalist scholar and you come across a case of genuine indeterminacy, you can pretty much do with it anything you'd like, as long as you're intellectually honest. You could throw up your hands and say, I don't know, let's move on to the next problem. Or what I think you ought to do is say, well, the extent of the indeterminacy depends on the standard of proof, cite my article on the subject, and then move on to the next problem. or anything in between. But if you're a public official, let us say a judge called upon to decide a case in which the sweeping clause or any other clause plays a role, the "I just don't know" response isn't available. You can't throw up your hands. I mean, metaphysically can't throw up your hands. Because to say that you're going to throw up your hands means essentially to leave the status quo where it is, which means the plaintiff loses. All right? As the rock band Rush said in one of its songs, if you choose not to decide, you still have made a choice. So that option is not available even in theory. So we have to have some systematic response to the problem of indeterminacy when we find it. And indeed, in the course of this conference, we've already heard some of the candidates for a response aired. One possible answer is to say, when we have a case of genuine indeterminacy, the government wins. That is, at least in the context of judicial review, when you're asking whether you can invalidate an action by a governmental body. If you can't meet the relevant standard of proof so that the answer is indeterminate, that means the challenged law stands. Lino Graglia defended that position quite eloquently, and indeed, I would point out, Lino combined answers to both the standard of proof and burden of proof problems. What Lino was saying is we're not going to find a constitutional provision determinate unless it meets a very high threshold of proof, like beyond a reasonable doubt. And if there is any doubt, we're going to resolve it in favor of the challenged law. And that is a position with a very impressive historical pedigree. Michael Perry mentioned part of that pedigree on the last panel. James Bradley Thayer took very much the same position. As did, by the way, virtually everybody in the founding generation who had anything at all interesting to say about judicial review. So it's not a position that can be dismissed lightly. But it's not the only possible answer to the indeterminacy problem. Randy Barnett, in some of his prior writings, has at least suggested the outlines of another answer, which is, in the case of indeterminacy, the government loses. What Randy intimated at in several prior articles is that the 9th and 14th Amendments generate what he has called a presumption of liberty, which essentially is a way of resolving problems of indeterminacy in these kinds of cases, resolving them exactly the opposite way that Lino Graglia would resolve them, against the challenged law, against the exercise of government power, rather than for it. Now, I have a great deal of normative sympathy with the presumption of liberty, but I do have some questions about whether the 9th and 14th Amendments can actually generate it. And that leads to the last point I want to make in connection with this. Can we find an answer in the Constitution to any of these problems? And the answer is no and maybe. No, I don't think the Constitution tells us what the appropriate standard of proof is. I don't think it tells us how much evidence we need in order to determine whether a particular answer we've come up with is correct. That has to be derived somehow from theories of interpretation and theories about what you were doing, and I'll have to leave that for another time. But I think the Constitution may be more helpful with answering the question about, okay, we've got indeterminacy, now what do we do? I'm going to come out actually more on the side of Lino Graglia than probably he expects. Think about how we deal with burdens of proof in other contexts, be it a high school debate or a civil or criminal trial. The usual rule that we put forward for allocating burdens of proof is he who asserts must prove. That is, there's always a presumption in favor of whatever the status quo happens to be, and anyone who's seeking to change the status quo to convince us of a proposition bears the burden of establishing it. Well, how would that fairly simple common sense principle play out in constitutional adjudication? Well, it would depend upon which level of government you're talking about. Think about a federal statute. Well, the first question with respect to any federal statute is, does the national government have the power to enact it? Right? The government is always in the position of, the federal government is always in the position of being the asserter, trying to establish that it can change the status quo, that it is somehow authorized by the Constitution. On that simple principle, any indeterminacy about the scope of national power, which, if I'm right about the sweeping clause, is virtually every question of constitutional law, all of those questions get resolved against the government if there's indeterminacy. If you can't establish the meaning of one of the granted powers provisions, then you can't say definitively, yes, the national government has the power to do this, and the government loses. If that hurdle is cleared, the national government has the enumerated power to do the thing in question, and then the citizen wants to invoke one of the affirmative rights provisions of the Constitution, the burden of proof, it seems to me, shifts, right? Because now it's the citizen that is making the claim about what the text does or does not do. The citizen is in the position of asserting and therefore would have to bear the burden of proof. Now, as I said, because virtually every question of affirmative rights turns out to be a question of enumerated powers, that's not quite as threatening as it may seem, but here's where Lino can celebrate. Where the federal Constitution is concerned, the situation is exactly the reverse where state governments are concerned, because state governments don't have to turn to the federal Constitution for grants of power. Federal Constitution presumes that they have the affirmative power to do things in the first instance, and it's only if there's an affirmative prohibition that says that they can't. So in that range of cases, the burden of proof would be on the person challenging the government law to show that, yes, definitively, with whatever standard of proof we're going to require, the Constitution forbids the state from doing what it's doing. And it seems to me that that common sense allocation of burdens of proof conforms very elegantly to pretty much anything we could know about what the original design of the Constitution would be. A limited national government, a presumptively unlimited a state government, and we have to go from there. So I will leave further speculations on this to questions and discussions.
In some respects, our panel reminds me a little bit of the story. I don't know who it was told about. I think it was about some kind of famous judge who, to whom someone posed the question that's often asked about law and judging, along the lines of, what do you think? Do judges make law? And the judge paused for just a brief second and then said, hell, I've made a few myself. What that reminds me of is that everyone that you see up here on this panel is here primarily because they've written a fair amount about constitutional history, offering up constitutional claims about the meaning of that history and about its determinacy. So it's interesting that that some of us seem to be engaged in an enterprise that we're deeply skeptical about. This is perhaps the most universal objection to originalism, namely that it is impossible because the historical materials simply do not yield determinate answers to any questions worth asking. But it seems to me that this objection lacks significant force for at least three reasons. First, the claim that the interpretive materials are always indeterminate vastly overstates the uncertainties involved, and moreover vastly understates the importance of the originalist canon as a tool for reducing the degree of indeterminacy that we might find in the materials relating to constitutional interpretation. The indeterminacy objection, in fact, it seems to me, trades on a vital assumption, namely that originalism's claims turn on its ability to generate clear and definite rules as to which there is never any doubt as to proper application. While I certainly agree with Rick Kay that certainty is one of the values that helps to explain and justify a commitment to originalism, This does not, in my view, imply that that the elimination of all interpretive discretion is the central goal of originalism. The attempt to fix rules in a written constitution, which is a lot of what, that's the notion of constitutionalism that originalism seeks to explain, necessarily competed with the goal of preventing the erosion of the protections placed in the Constitution by the drafting of unduly specific provisions that could be evaded over time. And that's one of the things that sets up the tension we have between the idea of a fixed written Constitution and the notion of one that is going to stand the test of time. Second, methods of constitutional decision-making that are offered as candidates to be substituted for originalist interpretation are without question at least as indeterminate as, and indeed generally more indeterminate than, originalism itself, considering that non-originalist methods might well be brought to bear in cases in which originalist methods fall short. An originalist canon, in theory, then, seems to me to only yield us a net gain with respect to the problem of determinacy in constitutional decision-making generally. Paraphrasing Jefferson, then, on the value of a Bill of Rights, if determinacy is a value at all, why not have at least half a loaf? Finally, since virtually no one contends that the original materials, text and contextual materials, are completely irrelevant to the task of giving effect to the Constitution, and indeed, I think we've heard that as a theme by a great many of the commentators who have rejected originalism, is the idea that the original materials are nevertheless relevant, if not dispositive of what we're trying to do, then it seems to me that a rejection of the view that originalist materials might yield binding answers to important questions really contributes nothing to avoiding the only evil visited by the frequent indeterminacy of originalist materials, which is namely the tendency of interpreters to claim certainty where it does not exist. So it seems to me that what is called for is the employment of care in the use of historical materials to avoid overblown claims as to what we can and do know, whether or not we adopt originalism as a primary canon for constitutional interpretation. I should add, moreover, that in my experience, non-originalists who have rejected the binding effect of original interpretation have consistently used and abused the historical materials in offering a variety of claims, and in particular concerning the founders' own commitment to the originalist canon, at least as often as the originalisms who they sometimes charge with naivete and with abuse of historical materials. Now, this is not the forum in which to try to demonstrate all of these claims fully, but let me briefly elaborate them just a little bit more. First, the claim that original materials often can and do provide definitive answers as to important questions. The proof is really in the pudding, and my experience in doing historical research is that there are numerous examples of where historical materials are absolutely decisive. The only question is whether we want to be bound by them. I might add here that the degree of debate may well, in some cases, be a sign that the historical materials are subject to competing interpretations and are indeed indeterminate, but that seems to me to not preclude the possibility that if you go ahead and spend those hours in the library, that you might not be able to resolve the question. The fact of disagreement doesn't seem to me to establish the proposition of indeterminacy. I have elsewhere attempted to demonstrate that the nearly universal criticism among scholars of the Supreme Court's decision in the slaughterhouse cases, to use one example, namely that it gutted Section 1 of the 14th Amendment's Privileges and Immunities Clause, can be decisively shown only by reliance on an originalist canon and the arguments that come from originalist premises. It seems to me that not even the textualist canon that some have proffered at this conference, considered independently of historical context, can accomplish that task. As I've suggested, I've tried to document and prove this somewhere else. In my view, the originalist materials are overwhelmingly persuasive as to the intended meaning of the clause granting to Congress power to declare war, as is the correctness of the holding in Barron versus Baltimore, refusing to apply the Bill of Rights to the states. Similarly, while, as you've already discovered, at least a couple of my panelists and some earlier speakers as well obviously disagree, in my view, the original meaning of the Ninth Amendment falls out of the historical materials quite nicely, so long as we don't bring modern presuppositions to those materials. Even if there are many issues which the originalist methodology will not definitively resolve, this would not detract from the importance of the issues which it can resolve, of which these examples are but a few. Now, there may be instances in which historical materials will be significantly underdetermined as a means of resolving any number of questions of application of constitutional norms. But many commentators, and unfortunately this includes both politically conservative and rigid positivists, as well as more leftward-leaning advocates of judicial activism, appear to assume that if legal and constitutional provisions do not embody concrete rules with clear-cut provisions, clear-cut parameters, it follows that they embody virtually or completely open-ended norms. Again, this is not a form in which I can completely engage all of the arguments that would have to be addressed here, but I just would say that in my view, Rick Kay is correct, that the historical materials may frequently provide us with clear answers to basic questions about the general scope of a constitutional provision without necessarily resolving every particular instance of application that we might struggle with. That's not surprising and is very typical even in the context of statutory interpretation and application. Moreover, oftentimes those materials will provide at least a frame in which contemporary questions of application must be addressed and thus establish boundaries as well. If I get time, I may come back to examples or provide that in separate discussion, but let me go on to the second, what I think is perhaps the more fundamental point, which is that non-originalist interpretive materials are invariably more indeterminate than originalist ones. Whether the question is framed in terms of tradition, consensus, functionalism, moral philosophy, and we can throw in Randy's idea of design as well. In the actual world of practice, we are even less likely to find a conclusion to which assent seems dictated. If I can engage in Professor Sherry's kind of exercise, I could observe that at this very conference we have Professor Barnett, for whom the Ninth Amendment spins out for us a sort of libertarian world along the lines of what you would expect from Professor Epstein. On the other hand, we have Professor Sager up here, for whom that spins out a world of affirmative government duties, minimum welfare entitlements, all kinds of things which Randy tells us by his design analysis would be precluded as inconsistent with the assumptions underlying our constitutional tradition and with its fundamental design. It seems to me that once the door is opened to a completely open-ended norm that says whatever is dictated by some notion of moral or political justice we're going to find to be among the rights that were unenumerated. At that point, it seems to me fairly clear that what we've done is substituted not just another constitutional order, but it's specifically anti-constitutional order, inasmuch as we at that point have no fixed boundaries or limits of any meaningful nature at all with respect to important areas of power, and in particular, especially judicial power. I'll throw in a brief advertisement since I really can't elaborate this point, which is that I have an article coming out in the USC, what is it, their Interdisciplinary Law Journal, that's based on a paper I gave at a conference this fall that's on this very subject, so I would just kind of commit that to you. Finally, I want to just illustrate this by what I deem to be a very powerful example, which is the filing of the brief by constitutional law scholars in the case of Dellums versus Bush, in connection with the Persian Gulf War. If any of you have read this brief, and you'll find that if you do, that it is signed on by a veritable who's who list of originalism's critics, you will find that there is not a truly non-originalist argument in it. There are some arguments from precedent, but all of the precedents use originalist canons. Every argument advances a view of the intended meaning of the Declaration of War Clause, supported by original materials and confirmed by case law. There's nothing about function, nothing about consensus, nothing about contemporary conditions in this entire brief. Now, why is this? The reason is pretty clear and obvious, and that is that the textual materials are vastly more decisive than any of these could be when they are read in historical context. There's no question that the Constitution was intended to put Congress in the driver's seat when it comes to making the decisions of when this nation will commit its resources to war. There may be doubt at the margins about the scope, exact scope of what was called the sudden attack exceptions, but there's no room for doubt about the operation actually deployed at the Gulf. The practical problem that creates for any good lawyer is precisely that to even open the door to the relevance and potential decisiveness of all these additional arguments is to risk very seriously the possibility that the court will throw its hands up and say, this is so complex and so indeterminate that I'm going to just rule that it's a political question and leave it to the other branches. What this suggests to me is that in fact it would be a very dangerous thing if we ever got to the point of saying that the original materials that give us decisive understandings of the meaning of texts were simply going to be determined essentially by some sort of fiat that they're just simply never going to be decisive. The final point I'd just like to make briefly is that the Dellums case, I think, illustrates something very important, which is that the really important question is going to be whether the historical materials in each particular case can really accomplish the task that is assigned to them. That's a debate that's not easy in any particular situation or case to resolve, and can only be resolved, it seems to me, case by case. But to the extent that there's a risk involved, it seems to me that that risk is there every bit as much. One of Judge Bork's harshest critics before the Senate Judiciary Committee, for example, Professor Tribe, relied on both textual and historical materials, the very stuff of originalism, for the proposition that the Ninth Amendment and other provisions of the Constitution were clearly intended to signify the notion that courts would be empowered to protect unenumerated constitutional rights. And for this reason, he argued, Judge Bork was not true to his own canon. It seems to me, I've got another paper that I could share with you, but I won't right now, that demonstrates how misleading and unhelpful to the Senate this presentation truly was. But suffice it to say that, in my view, Professor Tribe would have been better off to act consistently with his own previously stated convictions that we can never know historical materials with any determinacy than to offer these highly contested views as though they were incontestable scholarly conclusions. In short, it seems to me that the dangers of abuse of historical materials, which are very real indeed, is a separate problem that has to be addressed, whether or not we decide to adopt originalism as our primary canon of constitutional interpretation. Thank you.
Thank you, Tom. As Dan Polsby said yesterday, you've heard the panelists. Now it's your turn to do your work.
Thinking of individual rights cases, why should we look at the 1787 framers, think very much about the 1787 framers at all in terms of designers? Because, as Madison said in the Federalist Papers, what they were primarily trying to do was to determine the allocation of authority between the state and federal government, and to determine the structure of the federal government themselves, the Constitutional Convention wasn't very much concerned with determining the general shape of individual rights.
The analogy that I like to use to illustrate this important question is that of ship designers. Let's say that you have people who design ships to be seaworthy so they won't sink. They spend all of their time thinking about how to design a structure of a hull so that the ship remains seaworthy and won't sink. Then, when they invite the general public onto the ship, they assure you the ship is sound, it won't sink. Now, assuming some members of the general, and I would say that that is analogous to the position of the framers of 1787. The ship won't sink. We've designed it so it won't sink. Don't worry, get on the ship. Now, there were some people who weren't satisfied by that. They were worried. They didn't want to get on the ship. They were afraid. These are the people we now call the anti-federalists. To assuage those people, and in fact, the Constitution would not have been ratified had they not been assuaged, the framers were induced to put on the ship some lifeboats. They didn't think they were necessary. They didn't give the lifeboats much thought. They denied they were needed. But the people wouldn't have gotten on the ship without the lifeboats. I would say the lifeboats are analogous to the Bill of Rights that was enacted in was proposed in 1789. On the lifeboats are some life preservers. I think the life preservers are analogous to the unenumerated rights provisions of the Ninth Amendment. The framers gave even less thought to the life preservers than they did to the lifeboats, but they put them on the ship anyway. Now, 200 years ahead, or 150 years ahead, the ship sinks. Is it an appropriate response to say, don't get in the lifeboats, because the framers never intended that you should get in the lifeboats, which is a true statement, but I think a very poor reason for not getting into lifeboats.
Could I sharpen the question?
My argument is, you get in the lifeboat. You get in the lifeboat. The lifeboat sinks. The argument then is, don't use the life preservers because the framers never intended that you should do so. I think it's probably true, but a poor reason not to use the life preservers.
Could I, can I sharpen the question just a little more? Isn't there a distinction between the problem that Gary Lawson addresses, which is the problem that a large central government will oppress your rights, as opposed to the problem of that the states will oppress your rights, and weren't the framers of the 1787 Constitution and the 1789 Constitution addressing only the first? That is, they were concerned particularly with the very large central government.
Well, with some exceptions, of course, like the Contracts Clause, for example.
Clause, right, yes.
And in fact, James Madison did not share this view and tried to include in the original Constitution protections of the people from their own state governments and failed, which is one reason why we think Barron versus Baltimore was correctly decided as a matter of original intent. You're right. I mean, in that sense, I would say to that extent, you're right. That was what I called in my talk a design defect. The designers, it was a, not product liability perhaps, but there was a problem there. That design defect was corrected, I think, by the framers of the 14th Amendment. And so with respect, I mean, I think it was a big mistake myself. I think the inclusion of slavery was a big mistake. It may have been may or may not have been a political necessity, probably was, but it was a big moral mistake. And this was also of the same piece, a big mistake. And I believe that mistake was rectified in large part by the 14th Amendment. And so to address that concern, we have to look at the intentions of those, well, not look at the intentions, we have to look at the structure, how the structure was modified by the 14th Amendment.
Gary, did you want to address that as well?
No, I mean, I think Randy defended himself quite ably, and indeed, when in his discussions, he's very careful not to commit the fundamental fallacy that is often made in Ninth Amendment scholarship of presuming that the Ninth Amendment has anything at all interesting to say about what states can or can't do. It has a lot to say about what the national government can or can't do. And indeed, my only comment about Randy's point there is that he's even more right than he knows, because the Ninth Amendment, the lifeboats and the life preservers were already there even before they were added through the vehicle of the sweeping clause.
Yes, sir.
My name is Larry Myers from Brigham Young University. For Professor Sherry, going to your hypothetical, suppose I'm the judge and I've read your article and, say, Professor McAfee's article on whatever issue is that we're trying to determine the original meaning on, and I'm convinced that Professor McAfee's got it right and you've got it wrong. My question is, what do I do? For Professor Barnett, would you agree or disagree with Professor Lawson's default rule in the case of state claims?
The question of what you should do if you believe that one of us has it right and one of us has it wrong, I think sort of highlights a problem with both Tom's comments and Gary's comments about sort of what level of proof do you need and is there really indeterminacy. Gary says, well, you're asking for perhaps the best answer, but reasonable people will disagree about whether his interpretation of the sweeping clause is in fact the best answer. And Tom is saying that the Ninth Amendment is determinate based on his historical research. I happen to believe that it's indeterminate, but you could use some of my research to show that it's determinate in another direction. And then simply, is it my judge who's elected or who's appointed, or is it his judge who's appointed? What this does, I think, is strip from originalism its primary value of constraining the judge and making what the judge does less subject to being contested, because all it says is, well, you believe this set of historians rather than that set of historians, which is no better and no worse than saying, well, you believe this set of philosophers rather than that set of philosophers, since there is dispute.
Let me take this as my opportunity to respond to Gary's various suggestions, which I've been wanting to do. Let me first say that this is the first I heard them. I have a lot of respect for Gary. I admire him, and therefore I would like to think long and hard before giving a firm answer as to his suggestions. But let me give you my initial reaction. With respect to the federal government, first of all, the presumption of liberty that I have proposed as a doctrinal gap filler or substitute for the enumerated power, in part for the enumerated power scheme. I'm assuming it's gone. I mean, that's what Judge Bork tells us. It's gone. It cannot be revived. He said that not only in his testimony, but he said it in his book. And so we're supposed to give up on that. And if we take that as a given, then I believe the presumption of liberty is the appropriate default rule to use in that regime. Now, if you're going to revive the enumerated power scheme, as Gary proposes, we would be in a substantially different world, perhaps not needing the presumption of liberty quite so much. Let me give you an example. When Congress first sought to regulate the distribution of intoxicating substances under the Harrison Act, the Supreme Court and then the executive branch interpreted that as a prohibition of narcotics. The Supreme Court struck that down initially as unconstitutional, as violative of the 10th Amendment on the grounds that Congress had no power to prohibit these intoxicating substances, and therefore they wouldn't interpret it as anything other than a revenue act, which is what it purported to be under the taxing power. So in a world in which the Harrison Act is interpreted as merely a revenue act, which is what it's purported to be, and not a prohibition act, by virtue of the 10th Amendment, we would never need to reach the issue of whether the Harrison Act violated the rights retained by the people. Similarly, everybody thought that the Congress did not have power to prohibit the sale and manufacture of alcohol, which is why the 18th Amendment was ratified in 1919. It wouldn't have needed to be ratified if people had thought the Congress had that power. Look how far we've come today, where you wouldn't think about needing such an amendment to accomplish that end. If we lived in a world like that, then you wouldn't need the presumption of liberty nearly so much. I think you would still need it. Perhaps you wouldn't need it as much. But now let me address the issue of the states. I do think it's a mistake. I think my gut tells me it's a mistake to take the view that the government of the United States is a government of limited enumerated powers, but the governments of the states are governments of plenary, essentially unlimited powers unless shown otherwise. And I think I would offer two bits of evidence to argue that this is not the case. One is that the rights retained by the people, which are referred to in the Ninth Amendment, and this is the one sense in which I think the Ninth Amendment tells us something that's relevant to the states. The rights retained by the people referred, at least in large part, and even Tom will agree with this, although we disagree about judicial review, referred in large part to natural rights. And there's lots of evidence for why they referred in part, at least, to natural rights. And these natural rights, many of whom were thought to be unalienable rights, which means they couldn't be consented away to anybody. And the reason why the framers were committed to the doctrine of inalienable rights was because the British were arguing that the colonists had given their rights or had consented to the rule of Parliament, and the colonials argued not only did we not consent to this, but we couldn't have consented to it because our rights are inalienable and we can withdraw our consent whenever we choose. So the inalienable rights doctrine would suggest that these rights cannot be ceded to state governments any more than they can be ceded to federal governments, although the original constitutional structure did not empower the federal government to protect these rights from state intrusions. This, I believe, this was changed by the 14th Amendment. And let me add one other piece of evidence to support this interpretation of limited state governments. And that is that as soon as James Madison dreamt up the Ninth Amendment, which was an invention of him, it was swiftly incorporated after that into many state constitutions right away. They thought it was, as soon as the state government, the people realized this was a possibility for them, they put it into their state constitutions. If the state constitutions were charters of unlimited power, this would have been a non sequitur. And in fact, it's been argued that the Ninth Amendment is a non sequitur as applied to state governments, an argument that's refuted by the fact that the states themselves, in many states themselves, incorporated the Ninth Amendment into their early constitutions. In other words, showing that they viewed their own governments, and in fact properly so, as limited.
Gary?
Yeah, three very, very short points. First is, when I say that states are unlimited, I mean that only as far as the federal Constitution is concerned. The states certainly are limited by extra constitutional norms, such as state constitutions, or even inalienable rights. But just as far as the premises of the federal Constitution is concerned, they are presumed to be unlimited for that purpose. Second, with respect to standards of proof that Suzanna mentioned, I don't think I'd be prepared to argue very long that the interpretation of the sweeping clause that Patty and I put forward is true beyond a reasonable doubt. But I do think it is true beyond a reasonable doubt that it is the best available alternative. So you want to be very careful about the level at which you apply the standard of proof. Third, with respect to Judge Bork and the rejection of the doctrine of enumerated powers and the suggestion that we ought to surrender, we will fight them in the courts, we will fight them in the Congress, we will fight them in the law reviews, we will never surrender.
Pulled it out of the thing. Let me make a comment on two different points. One is the, just so that I won't be held as having ascended in silence here, it's important that you all know that I think Gary's interpretation of the sweeping clause is actually quite implausible and is not nearly the best supported by the historical record. I haven't been able to write that up yet, but I just wanted Gary to know that I felt that way about it. And I won't try to give you any of the details at this point. The second point I would just make is that we've heard about the history of the Bill of Rights debate, but the one thing that I think is important to understand is that James Wilson and Patrick Henry agreed about practically nothing, but the one thing they both agreed about during the debate over the ratification of the Constitution and the omission of a Bill of Rights was that the premise of the state constitutions was that everything not reserved to the people was granted to those state governments. Patrick Henry specifically made the statement, if we do not preserve them, we are ousted of our inalienable rights. Now, there is a possibility that Patrick Henry does not understand language and was speaking completely contradictorily. But another possibility is that he knew exactly what he was saying, and that what he was saying, basically, is that rights that are inalienable as a matter of extra-legal consideration of moral and political philosophy as the pre-constitutional assumptions of the order that we were going to be establishing through the Constitution, so that then it would be wrong for the people to cede up their natural rights. I might add that this theme of Henry's, if Henry had a misunderstanding here, a great many of his anti-federalist compadres did as well, because many of them who specifically elaborated on social contract theory in their speeches and writings against the Constitution specifically said that the whole purpose of the Constitution is for the people, as an original act, to be sure that they preserve their rights, and the failure to do so is to lose those rights, and they clearly thought the people had the right to do that, even though it was wrong for them to do that. This is what's called popular sovereignty, if you haven't heard of it.
Let me just take issue with one. I want to agree with most of what Tom says in that regard, surprisingly as it might sound. But let's take the 18th Amendment again as an example, because I view the Prohibition Amendment. I view the Prohibition Amendment as violating the natural background rights of the people. But there's no doubt that after it was enacted, it succeeded in doing that. I mean, that was what the law of the land became. And I believe it would have been a good argument against enacting it to say, if we do this, it will oust our natural right, our natural and inalienable rights, which is not to say that we would be divested of our natural and inalienable rights, but only that we will have created a governmental structure which is now empowered to violate them. Now, but the only place in which I'd want to disagree with Tom is to say that there's only an implication for the people ought not do this. There's a further implication, and that is if the people, or whoever that votes for this thing, does do this, they may be contributing to an illegitimate government, a government that ends up being incapable of binding the citizenry in conscience. So there is not simply, it doesn't just precede the people making a mistake, then once the people make a mistake, that's the end of the matter. The continued existence of unalienable natural rights means that even after the mistake is made, there are consequences to account for. Consequences that the government must account for and the majority must account for, and that is they may have created a sufficiently unjust regime that it has the power to imprison you, but it no longer has the power to bind you in conscience. And that is a major, that's an extremely important factor when it comes to, for example, justifying civil disobedience as well as the right of revolution.
What I'd like to do before the next question is to suggest that Tom's interpretation of inalienable rights as being, in a sense, alienable but not a good thing to do is indeterminate by quoting another anti-federalist. This is the Federal Farmer, and he says, of rights, some are natural and unalienable, of which even the people cannot deprive individuals. And then he goes on to say that there are others that can be ceded. So, I mean, and that is something that I happen to have with me in the material that I brought. If you gave me a couple of hours, I could find a lot of others, and I'm sure Tom could find a lot of statements on his side, which again suggests that history is not as easy as it looks.
I might just mention, though, that one of the statements on the other side would come from letters from a federal farmer himself. I think he's actually very clear, if you read him in toto, that although the people, in some sense, lack meaningful authority to give up these rights, that as a practical matter, as a matter of descriptive political and legal theory, they might fall into the trap of doing that, and that's something to work very diligently to avoid.
Yes, sir.
I want to take up the issue Gary Lawson raised here in his wonderful article, Proving the Law, about the idea of thinking about legal questions the way we ordinarily think about factual questions. I think there's probably a little bit more normativity to allocating burdens of proof
than you suggest
here, though not
more than you suggest in the article. In particular, I'm thinking about a case like Gomez against Toledo, which is a case I teach in civil procedure, which the Supreme Court says that the defendant must plead and prove qualified immunity. And the reason the court gives in the case is, well, it's an affirmative defense. But they also talk about the kinds of things that have to be proved. Well, at the time, one of the things that had to be proved was the subjective intent of the police officer. A pillar of which is gone now with a case called Harlow that says, no, that's not the case. And so we wonder who should have the burden of proof. Now, your suggestion was that in terms of federal authority, the burden should be on the government, whereas in the case of rights, it should be on the individual. It seems to me that as to the first question, that begins the question, right? But there's still the sort of normative question, the equivalent of the question in Harlow of, is it a good idea for the government to have the burden of proof, given the kinds of outcomes, et cetera, it's going to lead to? As to the second question, should the individual have the burden in the the individual rights case. Well, that sort of depends on your answer to what the substantive rights are. During the break, Akil Amar and I had an interesting discussion, which he told me, and I take his word for this, that the First Amendment, for example, was not originally intended as a right as a trump, but rather as a kind of restatement of the principle that there is no affirmative power on the part of the federal government to override rights of free speech, etc. If that's your view, then it seems to fall into the first category. But of course, you have to have an answer to the question before you know who gets the burden of proof. In other words, who has the burden of showing whether the First Amendment itself is intended as a limitation in the form of a structural limit or as a right as a trump. And on the ultimate question, it seems to me that the assumption that all of us seem to be sharing, that the more evidence, the better, runs kind of counter to your suggestion in your piece and today, that we treat this as a question of evidence, because after all, traditionally, the trial judge exercises quite a degree of discretion as to what we get to consider and what we don't get to consider, that is the jury. And we think that's a good idea, not just because of external policy reasons, but because too much information will sometimes overwhelm the jury. So contrary to Tom McAfee's suggestion, sometimes by looking at more material, you actually do get more indeterminacy. Now, that doesn't tell you which kind of material you should look at, but it seems to me if we're going to go in this direction of thinking of it as evidence, you have to think about these kinds of evidentiary considerations.
I agree with all of that. I think there are just incredibly complex and important normative questions involved in determining the standard of proof, determining the burden of proof. The very minimal point that I was hoping to make here, and I'm not sure even whether I was able to make that point, was to suggest that maybe there's something in the nature of this Constitution that suggests an allocation of the burden of proof. Even if I was right about that, there would still be the separate question of whether that is a normatively desirable allocation and to what extent people should be bound by it. But otherwise, yes, every single problem that was raised there, including the problem of information overload, is a valid and real one, and maybe one day I'll write a book.
Yes, ma'am.
My name is Meredith Parenti from University of Maryland Law School, and this is for Professor Barnett. I agree that there are unenumerated rights, but my question is addressed to the mechanics of discerning those unenumerated rights, and how can judges go about finding out what those rights are in a principled, restrained way without just giving force to their own political preferences?
Well, it's a very good question, and in my writings I've given a number of different ways in which there's a number of different ways in which I think this you can go about this. The one that I have emphasized the most is the presumption of liberty, which I didn't talk about today, which essentially is a burden-shifting device that puts the burden on government to show. Whenever a liberty is, well, let me start off. What's the baseline? What's the difference between liberty and license? I've really picked up in the middle of the story. I'm a contracts lawyer before I'm a constitutional thinker. And as a contracts lawyer, I spend 9 months out of the year exploring with my students a part of what their background rights are. The background right, in other words, what we do as private law thinkers in the subjects of contracts, property, and torts is try to figure out when has one person acted unjustly towards another person. We don't just say, you've acted unjustly. We have an elaborate, an extremely elaborate, more elaborate, I should say, than constitutional law ever gets, body of rules and doctrines and principles and theories to try to explain when one person has acted unjustly against another person. And you've all been through the first year of law school, and you've all experienced what that's about. I'm not saying it's a completely neat and easy picture, but it is a picture that has yielded results. My view is that that is the background. That's primarily a state law creation, I should say, and that's the background of rights. So that if the government purports to be telling a citizen that they shouldn't do X, but X is not a violation of someone else's rights as determined by this background set of concepts we know as contracts, property, and torts, and restitution, and there's other bodies of law as well, then the burden falls to the government to justify this interference with the rights retained by the people. So as a practical matter, the rights retained by the people are, in a sense, defined essentially by state law, in these various ways. And only if an individual is acting rightfully, according to this, may he protest that a government is interfering with his rightful actions. Unless the government wants to say, no, you've really acted unjustly towards someone else, which they very rarely want to say in defense of their regulations, because I think they're very rarely able to say it in any kind of plausible way, then the government faces a burden of showing that their actions are really necessary and really proper in the very same way that they would have to do so if they were interfering with speech. Not defamation, but speech. And if they're interfering with speech, they have a burden to overcome, and I'm simply applying the same protective burden to the other liberties retained by the people as is applied now in the area of speech.
I think that's an interesting question, and it is sometimes asked, although perhaps not in this case, as sort of a version of what Martha Nussbaum calls a principle that she says unites both Bork and Stanley Fish, who are different in every other way, that there is a theory that if not the heavens, then the abyss. Essentially, if we cannot find a way to absolutely constrain judges, whether that's originalism or minimalism or a doctrine that there are no unenumerated rights or various other things, well, then everything's up for grabs, and the only thing the judges can do is impose their own predilections. I think that that's incorrect. I think that there are lots of different things, including the background sorts of rights, including the common law method, that constrain judges from simply saying, well, here's what I think and this is what's going to happen, even if they are not ultimately constrained by originalism. And I understand that the last panel, which is on alternatives to originalism, will probably talk more about it.
Let me just clarify what I said, just because I see Professor Berger at the microphone here, and he and I talked about this last night, so I want to make it clear to him at least what I was intending by what I said. And that is that when I made a reference to the common law, I did not mean, in this case, a common law that says what's speech and what's not, a constitutional common law. I was referring to the common law of contracts, property, and torts, perhaps as modified by the state legislatures along the way. But that is the common law I'm referring to when I view that as the source of how we, as a practical matter, as a rule of law matter day to day, even though we might be wrong about it, how we institutionally define the background rights retained by the people.
Raul?
May I make 3 points? First, as to Randy's presumption of liberty and the burden of proof. In Erie against Tompkins, Brandeis, speaking for the court, said that when the federal government encroaches on the state domain, it has the burden of proof. So you've got a pretty solid authority there for it. Given the thrust to preserve states' rights, what Brandeis says is, you've got the burden of proof when you encroach on those rights. Point number 1. Point number 2. I'm rather disturbed by Suzanna Sherry's on the one hand and on the other, because then you can throw up both hands and say, a plague on both your houses. Mm-hmm. And then another thing I'd like to comment on with Ms. Sherry. It bothers me that you could bracket Fairman and Curtis, both equally fastidious scholars. Fairman, one of the jewels of American constitutional law, who finally was given the assignment to write 1 volume under the Holmes bequest, and I don't have to tell him about he deserves his renown. And Curtis, a backwoods lawyer, not a scholar, who made his whole career out of a sailing Fairman. Now there is, as Harold Lasky once wrote to Holmes, a hierarchy of authority. And Albert J. Knox says one of the sad things today is that anybody that publishes something is an authority. Yeah. Well, I just can't swallow that. And I may add, and I may add, by way of self-glorification, Ms. Sherry, I responded to Curtis, and Forrest McDonald, whom I'm sure you won't challenge as a really great man in our field, said that I just devastated him, and he only reproached me. He said, you used a cannon to blow out a rabbit. Now, the third point I want to make is this discussion of rights. We've got a sort of a feeling that, and particularly I think that Randy has it, that there's an illimitable field of rights. You just reach up to the great blue yonder and just pull down all sorts of rights. I've just finished a study. And I know, of course, some of my studies have met severe criticism, but they've never shaken me. As Don Marquis said about Mehitable the cat, there's still a dance left in the old girl. I found, going back to Magna Carta, that there were three rights they were talking about: the right of the property, and the right to life, and then the right to be free of imprisonment. That was Magna Carta. 400 or 500 years later, Blackstone enumerated the same three rights. The common law hadn't changed in those 400 years. The right of property, the right to life, and what he called the right to locomotion, freedom from restraint to go and come. And I found that formula, life, liberty, and property, was repeated in state constitutions with no indication that they were broadening the Blackstonian concept. As a matter of fact, as late as 1866, in the debates, James Wilson, who was the chairman of the House Judiciary Committee, read those three rights of Blackstone, and he says, this harmonizes what we have in mind with Blackstone. So to my way of thinking, to talk about rights as if you could reach up, and this was said by Alfred Kelly, as a vacuous concept that knows no bounds, just won't stand up historically.
Suzanna, do you want to take a first shot, and then Randy?
I guess all I want to do is let Michael Kent Curtis speak for himself. His book is called No State Shall Abridge the 14th Amendment and the Bill of Rights.
Randy?
I would just respond to the last part about the unlimited rights, or it's just reach up to the heavens and find rights. I do think that some things that divide constitutional thinkers are whether they take the view that first come rights and then comes government in order to protect rights, which is without doubt the Lockean approach, or whether they take the Benthamite and perhaps the Hobbesian approach, that first comes government and then comes rights. And this is the great divide. This debate has gone on for hundreds of years. It's going to continue to go on. I think I know which side of this divide most of the framers were on. I cite them as authority in the sense of Blackstone being an authority, in the sense of Kent being an authority, not in the sense of their being my masters, but as authorities in that sense. And if you take that view, that first comes rights and then comes government, then you have to believe that you can identify what these rights are with some degree of certainty. And I believe that you can, in an abstract way, and they're rather limited in an abstract way. And this life, liberty, and property is a nice summary of this. On the other hand, in a particularistic sense, they are quite unlimited. For example, they include the right to wear a hat or not to wear a hat, or to drink Diet Coke or not to drink Diet Coke, or go on the internet or not go on the internet. They're unlimited in that regard because these are simply all the things one can do with what belongs to one. So the first right is that you can acquire property, and that you can do with property what you will, as long as you don't invade the property of another. But what you do with your property, if you want to get very specific about rights, ends up sounding very unlimited because it's limited only by your imagination. Your abstract rights are not so limited, but the specific incarnation of these rights end up being unlimited. Let me lastly say, with respect to the disagreement that Professor Berger and I have on the Ninth Amendment, that as I told him yesterday, that if he could guarantee to me that at the age of 94, that I would still be doing the kind of work that he's doing and still be as active as I would be alive, number one, and I would still be doing the kind of work that he's doing, that I would recant my view of the Ninth Amendment and I would adopt his.
Time for two quick questions. Lino?
Then I won't comment on Randy's last statement about right, which a legal right, it seems to me, presumes a legal system. And to talk about a right in anything other than a legal right is simply a legally protected interest. Unless you're clear on that, and of course that requires a legal system, I think leads to enormous confusion. Apart from legal systems, it'd be very hard to see that any of the creatures out there, including human creatures, have much in the way of protection. The basic point I keep making, of course, is that the only real question in constitutional law is why should certain policy decisions be made by judges rather than by elected representatives. That we talk about interpretation, but in fact, to think about it realistically, you really realize no question of interpretation is involved. If you took any of these hard cases, and imagine you were a judge, say, boy, do I have a tough interpretation question here. I'm going to really do some good research historically and get the answer. You may well find, as Professor Sherry says, you're not going to get the answer. And all you'll be able to say is, it is not the case that I can say that this policy decision has been precluded from the elected representatives, and therefore I have no authority to preclude it. And your only question then would be, do you feel that you know the better answer to this than has come out of the political process? And do you also feel authorized as a judge to substitute your answer? Again, Professor Sherry is right that maybe it's not the abyss, or there's no limitations, but certainly since Brown v. Board of Education, the view of what is appropriate for judges to do is very broad. Let me get to the point I wanted to make, though, in response to both Randy and Gary. Randy says that, well, the problem with Gralia's approach is that the government always wins. Leviathan wins, and Randy's very much against Leviathan, although probably no more than I am. But Randy sees a protection from Leviathan by saying the judges can stop a lot of law. And I'm saying, now, all you've done, Randy, as a realistic matter, is transferred policymaking power to judges. And that's not an improvement on Leviathan. It really is worse, because you still got public officials controlling our lives, only now public officials over whom we have less democratic control. Well, Randy says that's not so. He just answered to the woman from Maryland. He says, no, he would just have the judges say there's a presumption of liberty, and unless the government can show that this law is reasonable and necessary in limiting liberty, then the judges hold it invalid. Well, all you have to do is ask yourself, is that a test that will in fact do anything other, put to anything other than the judges, than their view of what a good policy is here? See, the problem is, on every issue, the government has passed the law which restricts liberty, and now the only reason we can have this law, the only reason we have a problem is because we have conflicting interests we see as legitimate. And they're going to have to be evaluated in some way. And what Randy's suggestion amounts to, I maintain, as a practical matter, is that simply this policy decision on every one of these issues becomes for the judges. The judges believed, for example, in the Lockyer era, that a restriction on the hours of work was unjustified in terms of many. But, that's a debatable question. If we could state some principle, if we really could state some understandable principle like government should only act for the general welfare, and then give that really meaningful content so that the one who applies it is not just making the policy judgment, that would be another matter. I submit we can't. Finally, as to Gary also had sort of an answer. He says, well, I'm right to some extent, but the way to go with enumerated powers is this, he says. There, the government wants to change the status quo. They're kind of the moving party, the plaintiff, so they should have the burden of showing they do have the power. Again, I maintain that all that amounts to, in fact, in actual practice, is the judges get to make the policy decisions, which is always the issue. That is, the feds have the power to regulate interstate commerce. The power to regulate interstate commerce necessarily means that they can do an awful lot with intrastate commerce. You can't regulate interstate without intrastate. You do, when the court holds in Shreveport and so on, it includes the power to regulate things that merely affect commerce. Indeed, as Marshall said way back in Gibbons, it's right. There's no way to avoid that. If they can regulate interstate commerce, they have to regulate things that affect interstate commerce, or they don't have the power. Okay. Now the only question, but everything affects interstate commerce. Really does in some sense. And now the only question is, does it affect it enough? Or in terms of the policies involved, is any gain in national uniformity and certainty outweighing the loss in local autonomy? Now that's the only issue. Now the question is, as to each of these enumerated powers, should these decisions be made by Congress, or should they be courts? In the New Deal, there was a huge expansion. The people liked Roosevelt and voted for him. I never did. I was only 6. Unfortunately, I was 6, though. The people voted for Roosevelt, and should a court have been coming in and saying, no, these policies are bad? It seems like they're bad now. It wasn't so clear maybe they were bad then. And even that's the issue. There's no realistic alternative to the judges make these decisions. And that's the only thing worth discussing.
Gary, do you want to assume that was rhetorical, or do you want to try and answer it?
One sentence. Judicial review may be a really terrible idea, one of the worst inventions of modern man. Nonetheless, it seems to me that the arguments for Article 3 authorizing judicial review are, as a textual and structural matter, more persuasive than the arguments that it doesn't. So I do the best I can with what I'm given.
Very quickly, Randy.
Let me say that if you walk away from this conference learning nothing else, let me give you the following statement. Judicial negation is not legislation. Judicial negation is not legislation. The idea that the judges can negate legislation is not the same thing as saying they have the power to enact legislation. Things don't get to the judiciary unless they're first acted upon by Congress. They can't initiate on their own. And there's a huge difference. I agree it may come down to, at some point, a disagreement about what Leno calls policy, but I would refer to it often as principle, which is different than policy in my view.
Randy, the busing decisions would seem not to support that. That looks a lot like legislation.
I'm not going to defend. I'm not going to defend. I don't want to get into the busing decisions, but
Let's not.
But I would. But I wouldn't sit here and try to defend every activity by every court that's ever been made. I'm just talking as a general matter. I think what really separates Leno from me is what he just said. What do we think the world would be a better place if judges simply abdicated their checking function, and we simply had 2 branches of government? And I think I share the view of the framers that that would be a worse world to live in than the imperfect world in which we live in, where there's 3 branches, co-equal branches of government, and judges simply are empowered to, I'll pick up with what the metaphor that Lillian Bevere gave us yesterday, only I'll switch it now to Nancy Reagan, judges should just say no.
All right, very quickly, you've waited very patiently. Last question.
This again addresses Professor Barnett. It seems to me that your presumption of liberty, and as a way of shifting the burden of proof upon the government, what happens when, and you kind of intimated towards it, what happens when the government decides to pass a law that enhances liberty? Does it now have to shift of why it has the power to do that?
If the burden, as I said in answer to the previous question, in my view, the burden shifts when the government tells a citizen that he or she may not engage in what has been defined as rightful conduct by the background rules that tells us when we're acting unjustly to someone else. If the government is not doing that, for example, if the government passes a law that says their post office shall be open from this hour to that hour, it's talking about the regulation of its own facilities and its own offices. It's not telling the citizen what it may do in terms of engaging in rightful conduct. So I think it should at least be clear that I don't believe that every statute and every government enactment implicates the presumption of liberty, because not everyone tells us as citizens that we may not engage in rightful conduct. We may no longer own a gun that it, for example, defines as an assault weapon because of the way it looks. Not every government law is of that nature.
Tom, just a sentence or two.
Yeah, if you're interested at all in the historical question as to the actual attitude of the generation that produced the Constitution, I strongly encourage you to read John Philip Reed's book called The Concept of Liberty in the 18th Century. And I think what you'd find out is that I think that the founding generation would be as surprised by Randy Barnett's view as they would be by Frank Michelman's view that we have minimum welfare entitlements.
I'm going to make
not libertarians in the modern sense.
I'm going to make a few seconds worth of closing remarks, and then we'll let you go for lunch. I think it's fair to say that most of the legal academy thinks at the moment that the debate we've been engaging in today was conclusively settled in favor of the historical indeterminists. But I think that the legal academy and the academy generally has been so wrong on the nature of the world, as the events of 1989 in Central Europe showed, and the nature of this country, as the events from last November to the present are now showing, that almost all key political, cultural, philosophical, and ideological questions are ripe for rediscussion. If, as hinted at by John McGinnis yesterday, and by Richard Epstein today, and as I might add, discussed in my book referred to yesterday, the discussion now underway results in increased attention being paid to shared commitments to liberty, as Randy thinks, or to morality, or to Thomistic natural law, or to religion, which have actually been relatively constant over roughly 375 years of American history. We may discover that the original understanding, or if you like, Randy and Raoul's founders' design, is not so indeterminate after all. Thank you, and thank our panelists.